Now, for some perspective on this, let's bring in one of the nation's most prominent antitrust lawyers specializing in technology cases. Gary Reback was instrumental in the Justice Department's antitrust case against Microsoft back in the 1990s. He represents some of the companies complaining against Google and is a co-founder of the Open Book Alliance, a coalition he put together to oppose the Google book settlement. Gary is joining us now from Stanford campus in Palo Alto, California. Gary, welcome back to Bloomberg West as always. Now, you say that these allegations against Google could be more serious than those that faced Microsoft. Why is that?
Well, they're very similar allegations, and they're allegations that go to the core aspects of Google's business and the way they make money, which is mostly through search advertising. But I think what it would be most concerning to Google today is they're not just facing an FTC investigation. They've got privacy issues. They've got security issues. They've got issues with this Senate subcommittee. They're facing a whole panoply of problems, and that's very dissimilar from the Microsoft situation.
Now, have the complaints against Google been coordinated by Microsoft, or are there independent concerns out there?
I really don't think Microsoft has all that much to do with it. For example, the companies I represent are specialty search competitors of Google. These are companies in places like travel and comparison product shopping and local search who feel that they aren't being fairly treated because Google is manipulating search results. Microsoft does have some grievances against Google, and I believe I read that they filed a complaint in Europe over some of Google's conduct. But this conduct is different and broader.
Now, earlier I was speaking with Google's lead software engineer, Matt Cutts. I want you to take a listen to something he had to say in response to a question about whether using Google is a choice.
When you come to Google, it's because you typed Google in. No one comes to your home and says you have to type Google. And the reason that people like Google and that they use it and that Google has been successful is because we do a good job for them. If we don't do a good job, people will leave and they'll go somewhere else. And so we're very happy that people continue to choose Google.
Gary, do you agree?
No, I don't really agree. On one hand, Google says that consumers get a free choice. But on the other hand, all of these allegations are about how Google is making it as difficult as possible for consumers to choose other competitors when those competitors do a better job. Google's putting its search results ahead of competitor search results, even if competitors are better. Google's penalizing competitors. Google is taking competitors' content without permission. None of those is consistent with the notion that Google's doing the best job. If they're doing the best job, why do they have to preference their own results?
All right, now I want to bring in Cory Johnson, our editor-at-large, who was covering Microsoft back in the 90s and has been looking at similarities between the two cases. Cory?
You know, it's interesting to me, Gary, that when Microsoft wanted to get into the browser business, that's when they really ran into the problems of their exposure of their anti-competitive behavior. With Google, it seems like it's the same thing. When they've gone into other fields, you know, with the phone, with other things that they're getting into, that seems to be when these anti-competitive problems with their search results are coming up. Is that how you see it?
In part, Cory. I mean, as they've gone into these other areas, the problem is they've used the other areas to bolster and maintain their monopoly in search. So various analysts have pointed out that they don't really make all that much money off Android in the phone market, but it does help them maintain their search monopoly. That's very similar to the allegations against Microsoft.
Now, when you look at the way these cases might go forward, there are some really important differences between antitrust law in the U.S. and in Europe. How do you see the differences playing out in this case?
Well, Europe is very much ahead because they've started the investigation earlier. They got many more complaints, and they were much more forthright and vigorous about pursuing those complaints. So I think the biggest difference is going to be they might actually file a complaint before the FTC has acquired all the information that the FTC needs simply in order to make a decision. Beyond that, though, there are some differences in the substantive legal analysis, but that's not going to really make the big difference here. I think it's going to be easier to prove a case against Google in Europe, but it's not going to be that difficult in the United States either.
That said, though, isn't it going to be difficult to prove misconduct if in the U.S. it is not a crime to be big or be a monopoly?
Well, no one is making allegations about Google based on the fact that they're big. I mean, after all, they are big. The allegations go to things like manipulating search results and taking competitors' content without permission. And I believe Microsoft has an allegation in Europe that Google won't let YouTube be fully functional on the Microsoft phone. None of those things have to do with being big. They have to do with Google's anti-competitive conduct.
All right, Gary Reback, antitrust lawyer of Carr and Ferrell, thank you so much for joining us. We will continue to follow all of these cases across the country. All right.